All right, and this is people be Alicia Doxator. It's two files, 25-93382FH for a docket call and 24-93008FH for a probation violation from the same incident. Here. All right, and Mr. McClellan, is this your case?
This is Mr. Wirgo's case.
Mr. Virgo, do you have an amended information for the plea agreement here?
We do not, Your Honor. It would be forthcoming.
I strongly prefer them on the day of.
Yes, Your Honor.
Start doing that because I need to advise of the penalties. So tell me the penalties on your added count 5.
Your Honor, my apologies. I would have to myself.
It would be it's a 5-year max.
Okay. Okay, and the fine would remain the same, I think, under the attempt, right? So it's 5-year, 20,000. Okay.
And I noticed on that plea form as I was handing it to you, I think the one file number, the 93308,
Yeah,
that should be a 2024.
yes, that's right. That's right. Ms. Doxley, would you please raise your right hand as best you can for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, put your hand down. All right, Ms. Doxator, a guilty plea hearing is an important event, so I want you to listen carefully. If you have a question, go ahead and ask me. If you need to talk to Mr. Vogler, you just let me know, okay? The maximum penalty in count 4, vulnerable adult abuse, it's a misdemeanor punishable by up to a year in jail and or $1,000 fine. And then added count 5, attempted unlawful imprisonment, would be a felony punishable by a maximum of 5 years in prison and or a $20,000 fine. Do you understand that?
Yes, sir.
You are also on probation to me in the 24 file for domestic violence, third offense. That carries a maximum penalty of 5 years in prison. Do you understand that next?
Yes, sir.
Did you read and understand the rights listed on the advice of rights form?
I did.
And you signed that?
I did.
Any questions from your or your lawyer about any of those rights? And do you understand if you plead guilty, you'll give up all those rights and won't have a trial?
I do.
Is that what you want to do today?
Yeah.
And you understand you've got the right to have a hearing on the probation violation with the assistance of an attorney as well?
Yeah.
Okay. And do you wish to waive that hearing as well?
I do.
All right, the plea agreement provides that, I'm sorry, if I accept your pleas, you give up any claim that it was caused by any promises beyond this plea agreement. And you give up any claim that it was caused by any threats. Do you understand that?
I do.
Also, when you enter a plea, in the appeal, you'd have to get permission to appeal, use the right to appeal. And you'd seek permission by filing an application. But the types of issues you could raise would be very limited, much more limited than if you were convicted after a trial. Do you understand that?
Yes, sir.
All right, the plea agreement provides that for your plea of guilty to counts 4 and the added count 5 that I outlined, and understanding that that would also constitute a violation of your probation, the prosecutor will dismiss the remaining charges. There's a deadline for this that it would expire at the March docket call. So this would remain open for a month if you didn't want it today. And there's a sentence agreement that if I were to sentence you to prison, there'd be a 13-month cap on prison time, sentence within a guideline range of 12 to 24. And that cap would apply to both files, and any sentence would run concurrent. Do you understand the terms of that plea agreement?
Yes, Your Honor.
Mr. Vogler, is that a full, fair, and accurate statement of the terms of the agreement?
It is, Your Honor.
Mr. Wirgo?
It is, Your Honor.
Okay, counsel, if you just understand on the sentencing guidelines portion, the the parties can specify a sentence within, they can agree to a sentence within a specified range, and the sentence must be within that range. But I have an independent legal obligation, statutory obligation to score the guidelines appropriately. So how I score them might end up different from 12 to 24. I did not change the scoring to comport with a plea agreement, but to stay within a plea agreement, I have to follow and keep the sentence within a specified range.
If I may, Your Honor, then with language such as the parties agree that the guideline range for a factual sentence would be, or something along that line, as opposed to the guidelines will be scored at.
I honestly don't know what purpose this sentence scores in this plea agreement, where you have a cap anyway.
The cap was added later, Your Honor.
Okay. If you didn't have a cap, then it would just say sentence to be within a guideline range of whatever.
Perfect. Thank you, Your Honor.
All right, Ms. Doxator, that sentence agreement it all boils down to, in both files, there's a cap by this agreement that doesn't mean that I have to send you to prison, but if I decide to send you to prison, then the maximum sentence, or the cap on the initial sentence would be 13 months, be 13 months to 5 years. You get credit for time you've been in. And then at the end of that 13 months minus the credit, you'd be eligible for parole. Do you understand that?
Yeah.
Now that sentence agreement is not binding on me. If I wanted to give you more than 13 months, I don't have to stick to this. But if I didn't stick to this, you could withdraw your plea because you wouldn't be getting what you bargained for. You understand that? That's unless you engage in some misconduct between now and the sentencing. Say that you commit a new crime. Sometimes people do that even when they're in jail. You violate some court order, engage in serious misconduct. Then you lose the right to withdraw the plea, even if I didn't follow that agreement. Do you understand that?
Yes, Your Honor.
Other than this agreement, has anybody promised you anything to get you to plead guilty?
No.
Has anybody threatened you to make you do so?
No.
Is it your own free choice to do so?
Yes, Your Honor.
Knowing all this, how do you wish to plead to the charge in count 4 of vulnerable adult abuse?
Guilty.
And how do you wish to plead to what will be an added count 5, attempted unlawful imprisonment?
Guilty.
Your Honor, if we could just pause for a second.
Yeah.
And I want to talk to her a little bit about those guidelines, thing that we just went through.
Yeah, that's fine. Oh,
It's important because the 12 to 24, of course, leaves open the possibility of a county cap or a county jail sentence without any deviation. So I want to make sure she understands clearly what.
Oh, okay. I see what you're saying. Well, okay. Then that maybe helps me understand there is a purpose to that sentence. So I just want you to understand, I'm interpreting that sentence, the sentence in the plea agreement, that any sentence I imposed would have to comply with both a 13-month cap and would have to be within a specified range of 12 to 24. So even if the guideline score is 16 to 38, this plea agreement means the sentence must be within a 12 to 24 month range. Still leaves open.
All right, very good.
One other question I had, the principal offense of unlawful imprisonment does have a SORA notice. I don't know if the attempt would do so or if this is a SORA case.
I don't believe it's a sort of case as I review it. There's no minor involved
Yeah,
here.
and there is there was that case that said as applied to non-sexual offenders, it's cruel and unusual punishment. So I would not treat this as a SORA.
I don't think that would be that we're at risk at that.
Okay.
And the people stipulate this is a non-SORA case.
All right. Did you need a minute with her?
No.
Okay. All right. So, Ms. Doxator, Back in August 27th of last year, were you in Presque County?
Yes, Your Honor.
And were you caring for a Victoria Doxator?
I was.
And who is that person to you?
It's my mother.
Is she a vulnerable adult in some
She
way?
is.
In what way?
She's disabled. She cannot walk.
Okay, were you providing care to her, physical care to her?
Yes, Your Honor.
And did you take away her walker and her telephone?
Yes, Your Honor.
And did that prevent her from, did that restrain her movement?
Did.
And did that prevent her from telling somebody where she was at?
Did.
And you did those things without her consent?
Correct.
Mr. Vogler, do you believe that satisfies the factual basis for both
I do,
charges?
Your Honor.
Mr. Wergo?
I do, Your Honor.
And Mr. Vogler, oh, I'm sorry, and Ms. Doxator, you understand that part of your probation was that you not violate the law?
Yes, Your
Okay, so do you acknowledge then by your behavior with Victoria that you did also violate your probation?
Honor. Yes.
So Agent Leskey, as I'm looking at the warrant for plea today establishes count 5. And so I'll just dismiss counts 1 through 4 and 6. And count 5 is a non-technical violation. All right, Mr. Vogler, are you aware of any other premises, threats, or inducements?
I'm not.
Mr. Virgo?
None, Your Honor.
And Mr. Vogler, in your judgment, has the court fully complied with the requirements of MCR 6.302?
Yes.
Mr. Virgo?
The court has.
All right, Ms. Doxator, I find that your plea in both files is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of those crimes. So I hereby accept your pleas. Okay, we're gonna set sentencing in both matters for March 16th at 9:50 a.m.
Your Honor, I would ask at this time, given that her plea has been entered, whether or not the bond restriction with her mother, sister, and whoever other family members be lifted. There was a PPO against her, and I think her sister and her mother both came in and asked the family court to terminate that. It was done last week.
Mr. Virgo?
That is my understanding, Your Honor. The people would not oppose.
So I'll write on this docket call order. Bond remains revoked, but no contact provisions removed. And to the extent that you find that the jail needs something additional beyond that, you can get a copy of that, then you can just submit it.
Thank you, Your Honor.
All right, thank you. And have you had a chance to copy Mr. Board? Do we want to do that?
Mr. Gilbert, that was his case.
We're ready to go, Your Honor.
Okay.
He would take it.
Let's call it, this is an add-on